Welcome back. Ed Mahony is one of the state's great print journalists, a Pulitzer Prize winner, a two-time Polk Award winner. He's worked at the Hartford Courant for decades. I saw a recent story of his about a woman sent to a state mental hospital after refusing to share her ID. And I was only about halfway through it, and I texted our producer and said, you got to get Ed on the show to explain the story. Ed is here, one of my all-time favorites. I'm thrilled to have you on the show, Ed.
Thanks very much. It's great to be here.
So I told you, I gasped out loud several times while reading your story. It was about a week and a half ago in the print Courant. You covered a Supreme Court argument, and you described it as an unusually strong reaction from the justices. Give us a quick summary. How did this case come about?
This was a story of a woman who obviously had some troubles, but she tried to check into a hotel in Montville, Connecticut, and she wouldn't produce a driver's license for the clerk. And the clerk said, you can't have a room. There was no strong language or any hostility, but he said, you have to leave. She said she went and sat in a chair and drank a cup of coffee and tried to figure out what she was going to do next. In the meantime, the hotel called the police. The police came, told her she wasn't wanted. They demanded to know who she was, and she said, I don't have an obligation to tell you who I am. There's no law that says I have to, so I'm not going to do it. And he says, well, you're not wanted here. The policeman did. So she went to leave, and they grabbed her and said, you know, it's not that easy. You can't leave without identifying yourself. And she said, I'm not going to do it. He said, you're under arrest. He couldn't arrest her for refusing to identify herself.
Because that's not illegal.
It's not a crime. So they charged her with interfering with an officer. They took her down to the police station and locked her up. She refused to be fingerprinted, so they charged her with refusing to be fingerprinted. And that began, you know, an 8-month ordeal where she was judged to be incompetent, and she was sent to the state's maximum security forensic mental institution to restore her competency. She was sent to probate court. She was officially committed, and this procedure repeated itself 3 or 4 times up until June, when she finally got a new lawyer who challenged the competency and produced a private psychiatric evaluation which showed that she was competent. Coincidentally, the state at that point agreed that she was competent, and within a period of weeks, the prosecution had dropped the charges. You know, the defense and certain other people involved in this case say the implication is they realized the mistake they had made by putting this woman through the ordeal, and that's why they dropped it, to try and get out from under it. But they say it was just a coincidence. In any event, she filed an appeal in June, and a public interest appeal, which is not the normal kind of appeal. It's the court decided it was a matter of pressing concern, and they agreed to take it. And what they did was they got a lot of publicity about it to try, I think, to make sure that this doesn't happen again.
Well, and the justices for sure, now we should say, since Ed's article, the justices have dismissed the appeal,
right,
basically saying her charges were dropped, she's no longer in custody, so it's moot, we don't have to decide on it.
Right.
But in the meantime, they certainly gave the state a handful, an earful about their conduct. I mean, this lady, you mentioned probate court, she was conserved and forcibly medicated to restore her competency, all because she refused to give her ID. She was in court. She continued to say this was a false arrest. She had defense counsel who said, you know, I've tried to explain to her that she was arrested, and she's saying it's a false arrest. She, I think, accurately fought for her rights, and because of that, ended up being forcibly medicated.
I think so, yes. I mean, she was forcibly injected against her will with powerful, mind-altering drugs. And you know, there's plenty of indication that she understood what was going on. Her argument was, if you ever get me in court, I'll prove that I was wrongly arrested, and there won't be any need to detain me any longer. Somehow out of that, the evaluators at the mental institution decided that she didn't understand how the legal process worked.
Well, you know, you have a page here you gave me from the defense brief to the Supreme Court. She was medicated at least 5 times in 2024, talking about, you know, presumably other dates. And I just thought it was interesting here, Ed. I took this is a quote right from your article. This is Justice Stephen Ecker. He says this during what you covered. Her thinking is tangential because she keeps returning to the point that she's innocent, and this is false arrest. That's clearly a sign of schizophrenia because it's tangential thinking. That seems absurd. The idea that she's paranoid is because she's been involuntarily hospitalized by the state. He's basically saying, of course she's paranoid. You all have her locked up and you're forcibly medicating her for not showing her ID.
You know, what's interesting in this thing is if you're a court watcher, the justices who were once prosecutors were very, very silent during this whole argument, which went on about 45 minutes. The justices who never were prosecutors were the ones that had all the questions. The other thing I think you might want to be aware of is that the legislature became aware of this problem over the last year, and they enacted a law which took effect October 1st, just a couple of days ago. And it addresses the problem, but it doesn't really clearly direct us to any solution. It basically says that when this situation arises in the future, the people involved, the prosecutors in the court, should be aware that the goal is to find the least restrictive place to house somebody when they're going through this so-called return to competency.
Oh, and they send her to Whiting, which is the same place they send murderers.
Well, I mean, there isn't any
felons.
place many more restrictive than Whiting.
We're all out of time. But I appreciate you being here, and I think another interesting thing is, this all started because she couldn't post a $500 bond. That might have changed the whole point of this, and that's been a big topic in the legislature as well, that issue of judges putting people on bonds. $500, she couldn't afford to get a bondsman or otherwise put the money up, and that resulted in 8 months and 24 days, I think it was, or 20 days in custody, forcible medication. If you haven't read Ed's story, go on current.com. Ed Mahony, one of the great reporters in the state of Connecticut, and one of my journalism favorites. Thank you for being with us. A great story, and hopefully people will read it and it'll lead to some change.
Thanks very much.
All right, Ed Mahony, thank you.